Welcome to Brief Encounters, a DC Bar-sponsored podcast. I'm Joyce Williams, a member of the DC Bar, co-chair of the Human Rights and Immigration Subcommittee within the DC Bar's international law community, and founder of Anam Williams PLLC. Today, we are diving into U.S. immigration law at the intersection of policy and the rule of law, focusing on how legal structures, due process, and institutional design shape real-world outcomes. This is an area where what the law says and how it actually operates can look very different. So we're going to unpack what people who have worked in the system have to say on this matter. I'm very pleased to be joined by two distinguished former judges. Judge Andrea Sáenz is an experienced immigration lawyer, trainer, and writer with more than a decade of experience in immigration defense, appellate advocacy, and legal education. She's currently senior counsel at Co-Counsel New York and previously served as an appellate immigration judge at the Board of Immigration Appeals. We're also joined by Judge Anam Petit, a distinguished immigration attorney and former U.S. immigration judge, with experience both on the bench and in private practice. She's currently of counsel at Murray Osorio. Judges, thank you so much for being here today.
Thank you, Joyce.
Thank you.
I'm going to start with Judge Petit. To start as a foundational level, how is immigration adjudication currently structured in relation to the political branches? And what does that mean for judicial independence in practice?
So, in my opinion, the biggest structural issue is that the immigration courts sit within the executive branch under the Department of Justice, or DOJ, rather than as an independent Article I court. So, what this means is that adjudication exists within the very same branch that's responsible for enforcement, administration, and policy changes. And so, meaningful insulation, in my opinion, would require a few things, including decisional independence, protection from policy swings, and adequate court resources as well. And so, in practical terms, what that means is that we have clearer limits on top-down policy intervention. We have stable procedural rules. We have better staffing. And also, we need to seriously consider an Article I immigration court.
Thank you for that. And just a quick follow-up on that. So looking at the management of the day-to-day of the current immigration court, and maybe in future thinking of creating an Article I court, if we were to create that tomorrow, what problems will still remain, or what will the visibility look to people who are outside of the system?
Sure. So I think it's really important that we try to rebuild public trust in the immigration courts. We've seen an erosion of that public trust in recent times. And there are certainly lots of parts of the immigration court that can be improved on that are outside of that Article I structural change that I believe the courts need. We can improve training for immigration judges. We can improve on training for legal staff that assist the immigration judges. We can improve on judicial culture, docket management, transparency, procedural regularity. All of these can be improved on, and they would really improve on fair outcomes in the immigration court system. We can also try to reduce pressure on immigration judges. Right now, there's a lot of pressure on immigration judges to decide cases quickly and efficiently, and oftentimes that's at the expense of due process, which every immigrant in immigration court is entitled to receive. And we also shouldn't fire immigration judges without cause, because that certainly puts a lot of pressure on the system as well, and pressure on judges who are trying to do the right thing to also be worried about their own job stability. But there is a ceiling, because as long as we're in the executive branch, as long as the immigration court is housed there, complete independence will be difficult to achieve because many immigration judges almost have their hands tied behind their back and they can't actually do what they want to do to improve on that system. So I would say that the present structure can become more credible and fair, certainly, but it's never going to be the equivalent of a genuinely independent court system, which is what I think the immigration court needs.
Thank you so much for that. And with that tension between structures and practice, let's transition into looking at how that shows up into day-to-day decisions. So, Judge Sáenz, I come to you. What does this mean in terms of looking at cases with detention issues, looking at Section 235B of the INA, 236A, where you get more discretion in terms in bond and individualized custody decisions, and then 241, which governs after removal, someone has received final removals. How do you see all of this playing out together, and what does it actually look like in practice?
Yeah, thank you for that. So, for those who don't know, the number of people who are in immigration detention has really ballooned over the last year to the point that ICE has had to open all kinds of new facilities, and they've had to bring in, judges from cities that don't normally have a detained docket, and it's put enormous pressure on the system. And so right now we have over 70,000 people in detention on any given day. And because the current administration has chosen a policy of indiscriminately detaining people, it means that thousands and thousands of people who were having their immigration cases heard on the non-detained docket are now being rushed through the detained docket. So what that looks like in practice is huge numbers of people who are not dangerous, who are not flight risks, are being, in many cases, sent out of state, away from their families, and away from the opportunity to get counsel. And they really are up against almost insurmountable odds in either getting out of detention or winning their cases. And so for people so as you referenced three immigration statutes, it's very complicated, but the government is currently taking the position that all kinds of people who used to be eligible for bond are now being held without even the opportunity for a 5-minute bond hearing to see if they deserve to be released. And the immigration bar has had to invest enormous amounts of time and resources running to federal court trying to get people the right to a bond hearing one at a time. It's not sustainable, and there are people falling through the cracks because they can't access counsel. So I think that's the biggest impact for those folks. For the folks who are detained under what we call the post-order statute, meaning they already have removal orders, we're seeing all kinds of detentions of people who actually can't be removed because they have grants of protection to their countries, but the government is saying they're going to deport them to a third country. And actually, I think what some people don't know is that they're not being very successful at that. They are being very successful at holding people in detention, which is causing all kinds of humanitarian and medical crises for people, but they're not actually deporting that many people. So in practice, I think we're seeing a humanitarian crisis, and I think judges are having to deal with that every single day, and so is the bar. And I really worry for the people who are still trying to make the system work, and as well as the people who are being impacted by detention.
Thank you for that comprehensive answer. I think I want to explore a little bit. You mentioned the detained docket versus non-detained docket. And so to what extent does the detention itself really impact or shape the outcome of cases for individuals who are in removal proceedings?
Right. I think people would tell you that the ideal design of the system is that it doesn't affect the outcome of the case, but I think we all know in practice that it does. And the reason why is because people who are detained have a much, much lower percentage of being represented by counsel because they are moved far away from their families, because many lawyers don't or do detain work. Those cases are rushed to trial. They are even expedited more now than they used to be. It's very hard to gain evidence from detention. It's hard to talk to your family, to get your documents, to get them translated, to get them in on time, right? All of those things are incredibly difficult. And then for people who lose at the trial level, even who have great cases, being in detention itself has a coercive effect. So people give up and they accept removal orders even when they have strong cases because they can't stand another day in detention. And for those who don't know, immigration detention in most of America looks like jail. It's often physically using an actual county jail, or it's in very jail-like conditions. So it's not nice. It's not like a hotel. It's coercive, and people are suffering. And so as a result, it's much harder to win an asylum case than it would be if you had the time to prepare to make a, full evidentiary showing and come and testify in your normal clothes with your family supporting you.
And one last follow up on the subject. There are people who argue that the detention is operating as a legal necessity to really combat, quote unquote, rise of illegal immigrants in the United States. How do you respond to that? Is it a legal necessity or as a leverage in the system to really encourage people to self-deport?
Well, I think the idea that we should detain an individual person to have a deterrent effect on another person is not correct. I think everyone should have their own individual assessment of whether they need to be detained. I don't think historically it's shown to be accurate that people who are fleeing for safety would even know that the other people are being detained as a deterrent. So I think that's part of it. But also, I really wish in the future that the immigration system would learn from the criminal justice system, where there's all kinds of information and data on what causes people to come back to court. And there are all kinds of low-cost interventions that make sure that people can come back to court who are, living in the community successfully with their families, supporting their families and working, who don't need to be detained in order to ensure that they come to court. So I think the idea that we need a massive detention system, it's not just a philosophical question. It's a question we could actually study and have practical solutions. And I don't think that we need the size of the system that we currently see.
Thank you. So, Judge Petit, I'm coming back to you. The issue, so many questions, conversation has happened on asylum. We're seeing an erosion of protections under asylum, which is a humanitarian crisis. And so looking at the INA provisions and due process principle, what are the concrete limits on how far the government can go in restricting access to asylum?
Yeah, thank you for that great question. I'm glad you started that question with the INA, because that's where the right to asylum in the United States is the most concretely enshrined. And it's really important for anyone who isn't as familiar with asylum to know that it is a statutory right and that Congress carved that out. It is rooted in international law and international law principles of non-refoulement that we as a world have decided that we cannot remove people to countries where their lives would be in danger. And so it's rooted in that very strong international law principle. And then Congress, decades ago, created this right, and that right cannot be infringed. It is a statutory framework. Immigration courts exist to hear those cases for asylum. Asylum offices exist to hear those claims for asylum as well. And the executive really can't rewrite that statutory framework, whether it's through regulation or practice. In this administration, they are trying. We are seeing those efforts to chip away at a meaningful opportunity to present a case for asylum. And it needs to be counterbalanced with that statutory right. And you also mentioned due process in your question. There is a constitutional protection known as due process that each asylum seeker is entitled to. Our Supreme Court has held that emphatically, and every circuit court has affirmed that. There is no circuit split, or there is no confusion as to whether a non-citizen in removal proceedings has a due process right. They do. And so with those two combined, that means that a non-citizen who's physically present in the United States or arriving in the United States has a right to apply for asylum, and that needs to be with due process protections, which among other due process protections means that they have a meaningful opportunity to present that case, and it needs to be heard with fundamental fairness. Can it be regulated? Absolutely. There's process that can be put in place. There are regulations that can be enacted. But then the question becomes, do those regulations and do those procedural rules conflict with, or are they inconsistent with that statutory right to asylum? And courts need to be very skeptical when there is a purported procedural rule that functions as a barrier to asylum. And again, we're seeing that in this administration because we do have that basic principle that asylum law is a statutory right. And courts have to make sure that we're not letting that structure be narrowed beyond what Congress authorized. Just as one example, we are seeing this in the context of motions to pre-termit based on asylum cooperative agreements. We have a regulation and we have a BIA case that greatly expands the scope of those asylum cooperative agreements and allows immigration judges, and actually really requires them, based on the language of these rules in this decision, to not hear an asylum case and instead to remove people to third countries that the United States has an asylum cooperative agreement with. And so we've been seeing these motions be made very regularly in immigration court, such that our office has been seeing it in almost every non-detained case. We've seen an intermittent pause in that, but I think everyone's holding their breath as to when and if those motions to pre-termit will continue. But the result has been that many asylum seekers who do have a statutory right to present their case are not being able to present their case in immigration court and instead are being ordered removed to third countries. And so that's an example of kind of this conflict between rules that are supposed to be just implementing the right to asylum, but what they're doing is really just dwarfing that right to asylum and not allowing people to actually present their claims.
Thank you so much. To follow up, the law has not changed formally, but access is being narrowed. So, what are the legal or the constitutional concerns that this creates in our asylum, adjudication, and enforcement of immigration law?
So courts have to look at function. They have to look at the real practical implications and not just the form and not just the words on paper. And a policy doesn't just become lawful because it's described as procedural or screening based or efficiency oriented, whatever are the magic words to make it seem justifiable. If the practical effect is that it's preventing people from meaningfully accessing the statutory protection that Congress created for them, courts have to scrutinize that very carefully, and I hope that they do. So the analysis, of course, is going to be rooted in statutory text, congressional intent, and due process concerns. We always have to look at the Constitution and these due process rights that non-citizens are entitled to. And then, as Judge Sáenz mentioned, in the asylum context specifically, these small procedural barriers can have enormous substantive consequences. Because if people are detained, if they're unrepresented, if they're traumatized, if they're operating under severe time pressures, these result in unfair and unjust outcomes. And so that's where the concern is really the gravest for me, is that when policy narrows access before a full hearing even occurs, before that person even gets a foot in the door to present their case, then that is an unjust outcome. And it's not fundamental fairness that comports with due process.
Thank you so much. And so we look at this, and there's a balance or questions of legality and also practical accessibility. So, Judge Sáenz, let's look about the system design and implementation and how that is actually impacting when judges are applying the governing statutes and regulations, and where do those rules start to constrain outcome, particularly in cases involving release and asylum and withholding under the Convention Against Torture.
Yeah, thank you. And I appreciate us spending so much time talking about the asylum adjudication system, because I think that in the policy world, this gets talked about only in terms of the backlog. There's too many cases. There are too many asylum seekers. And I don't agree. I think this is a question of designing the system so that we can give people proper adjudications. And so what we've chosen to do instead in the last year, unfortunately, is to continue to tweak the rules, including the case law, to make it harder and harder for anybody to win their case. And the best example I can give is that since the time I left the Board of Immigration Appeals, I was fired last March. Since that time, the Board of Immigration Appeals has issued a historic number of precedents. I think it's over 80 at this point. And 99% of them, the non-citizen is losing. That's very strange. That's not how a court operates. Usually some people win and some people lose. And if we have all these forms of relief and protection in the INA, I think it's fair to say some people should get them and some people should not win. And I spent most of my career as a defense attorney, and I'm one now. So obviously I advocate for my clients to win their cases. But when I was a judge, I granted some of the cases and I denied other cases because some people meet the standards and some people don't. But what you see the Board of Immigration Appeals doing today is issuing precedent saying that nobody's evidence is good enough. Most experts won't be qualified. Most people's evidence will be seen as anecdotal. It won't meet the standard. Somehow it seems that every single fact pattern that's presented to the board is not enough to show persecution, is not enough to show torture, such that you now have a pattern where I can't think of any kind of case that they're agreeing is worthy of humanitarian protection, such that it's still on the books, as you say, but in practice, everyone is losing their case. And the other thing that's happening is that if immigration judges still grant a case, DHS is taking a huge number of appeals, which they didn't used to do, with the knowledge that the board is reversing grants of protection and ordering people removed. So you have a signal from the top that immigration judges should stop granting protection because it won't be upheld on appeal, even though the statute itself hasn't changed. I think it's enormously concerning.
To follow up on that, the U.S. is a common law jurisdiction, and one of the perks, if I must say, of common law judges is discretion to look at facts and be able to make decisions in that context, not very restricted. So given the example you cited with the Board of Immigration cases, almost about 90 or majority of them being on the losing side, and, trial judges probably don't want reversal as well. Do you think that is also eroding the discretion that judges previously have enjoyed, and now they feel compelled that it's become formulaic, 1 + 1 = 2, and that's it?
Yeah, I do actually. I think the agency, unfortunately, has done two things to try to limit people's grants of protection. One is to remove a bunch of judges that they thought were not ideologically aligned with them. But even among the judges who remain, I'm not going to criticize all of them. There are still folks trying to do their job every day. And in theory, the board is supposed to be deferential to immigration judges' factual findings. And I don't think that that's what they're seeing, because instead what you're seeing is a message that they'll be deferential only to a denial. And that if you find a way to find that somebody is worthy of discretion, is worthy of protection, has shown rehabilitation, that the board is likely to reverse that. So it does make a judge second guess whether their factual findings are strong enough to survive review. That being said, I hope they still make them, because the thing that the bar is doing, besides learning to be habeas corpus litigators, I hope, is learning to go to the circuit courts on petitions for review, because I think the circuit courts are going to continue, hopefully, to apply their standards of review and to say that the agency still has to follow the INA.
Thank you so much. I think we are going to shift gears and look at an issue that in the last couple of days, it's been in the news. Everybody's talking about it, and that's birthright citizenship. And the DC Bar is going to have a full-blown podcast on that, but I'll be remiss if I do not hear what your thoughts are. So I'll start with you, Judge Petit. What do you think? It's an established law? Should we leave it as is, or there is room? Where do you come out on this?
Sure. So I will caveat everything I say with, I am no constitutional law scholar. I am an immigration judge. I'm an immigration lawyer. And so it's a little bit outside of my day-to-day expertise, but certainly have some thoughts on it. It's a narrow question, which is what the Citizenship Clause means in the Constitution, and whether being born on U.S. soil is enough, apart from some historically narrow exceptions, or whether the executive can deny citizenship based on the parent status. And To me, it is very clear cut that they cannot. We'll see what the Supreme Court has to say. But there is also a larger constitutional question here, and the implications are also larger, which is whether a president can, by executive order, narrow a settled constitutional doctrine and guarantee and create a more conditional concept of citizenship that aligns with their own policy views to limit immigration and limit people's legal right to live in the United States with citizenship. So when I look at this case, it goes well beyond immigration law, but it speaks to separation of powers, constitutional stability, and the meaning of equal citizenship itself. And as someone who went to law school, even though it's been several years, it really upends decades of settled constitutional precedent. I would love to be a fly in the wall in Con Law 1 and 2 right now for law students to see how they're discussing this case. But it really flies in the face of what we have all learned in law school, regardless of what law school you went to.
Thank you. And Judge Sáenz?
So listening to the oral argument, I was really struck by the Solicitor General being seemingly very confident, saying things that I think were overtly anti-immigrant and also maybe not very legal. And I think that's what concerns me so much about this case, is that it seemed to be a way for the administration not to engage in really, rigorous legal interpretation, but to complain about the children of immigrants coming to the United States. I mean, you had the Solicitor General telling the Supreme Court that there's too much birth tourism, that people are coming here to have their babies on U.S. soil. I think he said, billions of people around the world are a plane ride away. That's a policy statement. That has nothing to do with what the 14th Amendment means. And there are ways for us to control who gets a tourist visa that don't require upending an incredibly important part of the Constitution. And so I really think this case is about whether the 14th Amendment means what it says. And I worry that it was a way for folks to shift the what's normal, the Overton window, to talking about something that really is settled. And I'll steal a line from my immigration professor, Gerald Newman at Harvard, who has talked about birthright citizenship being one of the reasons why the United States has a non-racial identity. What it means to be American is not racial because anybody can become American. And that's so important. It's one of the things I love about immigration law, about how diverse this society is, how people can come here and become Americans and their children are Americans. So I think that the right side is going to win the citizenship case, but I think it was concerning that it happened at all. And I hope that the decision we get is very strongly worded and it affirms what's really important about birthright citizenship.
Thank you both. And now to our final question. So looking ahead, what is one reform you think could realistically happen in the next few years? And what is the biggest risk if nothing changes at all?
I think there's the reform I want to see, and that might not be the reform that I think is realistically possible in the next few years. But the reform I would like to see is an Article 1 independent immigration court system. I believe that this administration has shown how easy it is to take advantage of a already vulnerable institution given a flawed structure, and how you can really exploit that to attain your political policy goals. The immigration court system has always been like this. We have always been susceptible to exploitation because it's housed in the Department of Justice. We just historically haven't had too much legal whiplash. There's always been some whiplash, but not like we've seen with this administration. And so I hope Congress sees what has happened in this administration, has seen the firings of immigration judges without cause, really great immigration judges who had high completions, had fair outcomes, who cared about due process, who come from varied backgrounds, former DHS prosecutors, former judges, professors, private practice, nonprofit. It is a wide range of people. And they have all been good judges who have been let go. And on top of that, just this dismantling of a system, we could talk about ICE being allowed into courthouses to detain immigrants who are doing the quote unquote right thing by attending their hearings, and the climate of fear that that has resulted in, and that being permissible because they do have a lot of power to do that. And just judges not having power to really adjudicate their dockets and manage their dockets in a way that does ensure high completions, which should be a mutually shared goal and isn't a partisan issue, but also while still having fair outcomes and due process. And so I hope Congress sees what has happened in this administration and really thinks, wow, we really do need an independent Article 1 court, and we need to make sure that there is more stability in a system that really has high stakes. We're talking about life and death consequences in many of these cases. Immigration court has aptly been described as death penalty cases in a traffic court setting, and it just shouldn't be that way. And so if policymakers and if members of Congress really want public trust in a system that is really a linchpin in our government and in our institutions, we have to build institutions in an immigration court that can deliver that principled adjudication, not just under the whim of whoever happens to be in the White House.
I'll answer that question from a slightly different angle, but I think with the same intent, which is I'll swing for the fences and say what we really need is more ways for people to get permanent status that are not through immigration court. We're asking too much of the immigration court system. We have too many people in the immigration court system who would be wonderful Americans if only there were some way for them to regularize their status. And we can do that. It doesn't have to be, people use the phrase comprehensive immigration reform or amnesty, and we don't even have to use those big words. If there are additional paths, there are all kinds of people who are currently on a path to a green card in a category that has a years-long backlog. And if we were able to put a few more visas in the line, those people would be in status and there wouldn't be any reason to use the immigration court system to try to sort them out. So we need to take thousands and thousands of cases out of the immigration court system and let people apply for a green card, however that has to happen, and use the immigration court system much more sparingly for the folks who really need a complex adjudication of whether they need to be deported from the United States. That's my big dream. On the smaller level, I really hope that the next administration that comes in can recommit itself to asylum and due process being real concepts that go together with efficiency and case completion. As Judge Petit has said, I think many, many past administrations have focused entirely on case completion, going quickly, eliminating a backlog without thinking about what the consequences are for human beings who aren't getting due process and who may be returned to harm. I do think we can balance those things and we can put in the procedures and personnel that care about them. So that's my hope.
Thank you both so much for such thoughtful and insightful discussion. I'm just really excited. And I hear the passion also come through. So this has been really engaging conversation. And I think it brings into focus not just the complexity of immigration law, but the real world impact of how these systems operate. So I truly appreciate your time and insight. And thank you to our listeners for joining us on Brief Encounters, a podcast sponsored by the DC Bar. Thank you.